Hi, my name's Chris Nolan. I'm a barrister at Queen Victoria Chambers in Sydney. This video is called Costs Against Police, and it's designed to assist legal practitioners in the local court of New South Wales. There's a link to the associated paper in the notes below. Traditionally, courts did not make cost orders in criminal matters, but that all changed in 1990, and the leading case is called Latutus and Casey. Mr. Casey was a police officer who charged Mr. Latutus. Mr. Latutus beat the charge and applied for a cost order, which was refused, and he appealed that all the way to the High Court and got up, and that's why it's now the leading case in Australia. The ratio of the case and the most important paragraph is in the judgment of Chief Justice Mason. It's found at page 442, and I'm going to read it to you now. In the ordinary circumstances, it would not be just or reasonable to deprive a defendant who has secured the dismissal of a criminal charge brought against him or her of an order for costs. To burden the unsuccessful defendant with the entire payment of the cost of defending the proceedings is in effect to expose the defendant to a financial burden which may be substantial, perhaps crippling, by reason of bringing a criminal charge which, in the event, should not have been brought. It is inequitable that the defendant should be expected to bear the financial cost of exculpating himself or herself, though the circumstances of a particular case may be such as to make it just and reasonable to refuse an order for costs or to make a qualified order for costs. So that is extraordinary, because he's now saying that the default position is that a successful defendant should get a cost order, and it's only in exceptional circumstances that the court should refuse to make a cost order or to make a qualified cost order. So, as you can imagine, the New South Wales government foresaw an avalanche of cost orders being made against the police, and they very quickly intervened and amended the Criminal Procedure Act to limit the circumstances in which the local court could make an order for costs in criminal cases. So the important parts of the Criminal Procedure Act are sections 212 to 216. Section 213 gives the local court the power to make an order for costs in criminal matters, and however, that power is limited to the four circumstances listed in section 214. Those circumstances are, firstly, that the investigation into the alleged offence was conducted in an unreasonable or improper manner. Secondly, the proceedings were initiated without reasonable cause or in bad faith, or were conducted by the prosecutor in an improper manner. Thirdly, the prosecutor unreasonably failed to investigate or to properly investigate any relevant matter of which it was aware or ought reasonably to have been aware, and which suggested either that the accused person might not be guilty or that for any other reason the proceedings should not have been brought. And fourthly, when there are exceptional circumstances relating to the conduct of the proceedings by the prosecutor, and it is just and reasonable to award professional costs. So when you make your application for a cost order, my advice to you is that first of all you print out my paper, which you can find at the link in the notes below. That paper is 2 pages. If you print it double-sided, it'll fit on one piece of paper. Print 2 copies, hand one up to the magistrate and hand one to the prosecutor. The reason it's important is on the first page of that paper you have the important section from Latutus and Casey. So you've got a High Court authority saying that the default position should be that a successful defendant should have their costs. If you then turn over on page 2, you have section 214 and the 4 circumstances in which the court is allowed to make a cost order, and it's up to you to then explain to the magistrate why your particular case falls into one or more of those 4 circumstances. Now, police will often oppose your application on the basis that they were unaware of whatever circumstances made their prosecution improper. So it's always very handy if you can produce written submissions. So I'm a big fan of written submissions. I often write to the police commander and invite the commander to withdraw charges. Firstly, because sometimes they do, if you can persuade them that they have a problem with their case. But secondly, if you do get up in court, you can hand up those submissions and you can say, Your Honour, I told the police ahead of time that they had a problem, and that made this prosecution improper, and that's why I deserve a cost order. So I'll give you an example. Last month I was in the Downing Centre. I had a client charged with drug possession. Now, he had been standing on a street in the Haymarket at 11 o'clock at night. A car had pulled up and stopped for 30 seconds. There had been an interaction between him and the driver, and then the car drove on. So the police, on the basis of that, thought that was a drug transaction, and on that basis they stopped him and they strip searched him, but did not find any drugs. However, after strip searching, which took about 40 minutes, they then found some drugs on the ground. And they said these drugs belong to my client and charged him with possession of a prohibited drug. Now, the problem the police had is that there was no fingerprint evidence, there was no DNA evidence, and there were no witnesses who saw him discard the drugs. So I wrote representation to the police and I said, look, burden's on you to prove beyond a reasonable doubt that my client had exclusive physical control of these drugs. You just can't do it. Without DNA or fingerprints or witness to say I saw him discard those drugs, you can't meet the onus of proof. You should withdraw this charge. And I also pointed out that I was at a loss to understand what in those circumstances justified them strip searching my client. So at the end of the hearing, the charge was dismissed, and I handed up my paper on costs, which the magistrate wasn't particularly interested in. No doubt he'd heard 100 cost application, was very familiar with Latutus Casey and with section 214. However, he was very interested in the representations I'd written to police because he could see that the police had a problem. I told them about it ahead of time, and he was really in two minds about whether to make a cost order. Now, ultimately, he did not, because he said, yes, it's a circumstantial case, but it was a strong circumstantial case. And he's not going to, and the police often bring circumstantial cases and they get up, so he's not going to make a finding that it was improper simply because it was a circumstantial case. However, he did share my view that the strip search was unreasonable, and he asked me if I was relying on that as a special circumstance under subsection D, and I said that yes, I was, but he was of the view that, look, your client might have grounds to make a complaint to the LEC, and he might even have grounds for a civil suit against the police, but that's not an exceptional circumstance that would cause him to make a cost order. Many times throughout my career, I've attended court ready to run a hearing, and the hearing hasn't run because the police are not ready to proceed. And there's many reasons for that. It might be that they haven't served part of the brief, or they haven't been able to serve a subpoena on a particular witness. Now, they will seek an adjournment. Of course, I'll oppose that, but if that adjournment is granted, I always apply for a cost order on adjournment under section 216 of the Criminal Procedure Act. Now, magistrates don't like to make such cost orders because they feel they have to make an adverse finding against the police. So it's better to frame it differently and say, it's not that the police have done the wrong thing, but that the police should have told the defense and the court in advance. If they failed to serve a subpoena, they knew that a week before the hearing, and they could have notified the defense and made an application to vacate the hearing. And then I can say to the magistrate, look, had they told me this ahead of time, even yesterday, I wouldn't be here. I'd be working for another client and billing my time to that client instead of coming here today and billing my time to this client, and he's getting no value in return. And when you phrase it in those terms, it is a powerful argument, and it's very difficult for a magistrate to refuse a cost order in circumstances where the police have failed to inform the defense and failed to inform the court that they won't be ready to proceed on the day. Thank you for your attention.